Want to hear a story about In Defense of Angels? I stood before the bench, my fingers brushing the frayed edges of the poet's journal. The pages trembled in my grip, not from nerves, but from the weight of the argument I was about to make. One that would either cement my reputation as a legal hack or redefine how this court valued the intangible. Your Honor, I began. This case hinges on a question our statutes have never squarely addressed. Can destruction of the unseen be a harm the law recognizes? The defendant, a construction worker named Carl Merton, slouched at the counsel table. His attorney had smirked through pretrial motions, insisting the case was frivolous. After all, Carl had only trampled a patch of wildflowers near a public trail. But to my client, Eleanor Voss, those flowers weren't just flora. They were the subject of a decade-long poetic cycle, a bridge to the divine, as she tearfully described them. The judge arched an eyebrow. Counselor, the plaintiff admits these flowers grew on public land. No property rights exist here. Respectfully, Your Honor, this isn't about property, I said. It's about perception. When Mr. Merton bulldozed that meadow to shortcut his hike, he didn't just crush petals. He destroyed a lexicon. I opened Eleanor's journal, reading aloud. Crimson threads of dawn's whisper, each bloom a psalm unheard. Poetic, the judge conceded, but not a tort. But intent makes the tort. I gestured to Carl. He admitted to investigators he found the field useless. His disdain was deliberate. And under Hernandez versus Latimer, intentional destruction of culturally significant art, even if not owned by the plaintiff, supports a claim for emotional distress. Eleanor's quiet voice cut through the room. That field was my cathedral. The defense lawyer snorted. Your Honor, this is mystical nonsense. Should we sue every kid who picks a dandelion? I set the journal on the rail. In 1923, this court protected St. James Chapel's stained glass. Not because the plaintiffs owned it, but because its beauty was central to their community's identity. Eleanor Voss's relationship to those flowers is no different. The value Mr. Merton obliterated isn't monetary. It's the right to wonder, to connect. The judge steepled his hands. For a breathless moment, I feared he'd dismiss us. Then he leaned forward. Counselor, write me a brief analogizing this to Hernandez. I'll hear arguments next week. As we exited, Eleanor clasped my arm. You saw it too, didn't you? The messengers and the petals. I glanced back at Carl, who scowled as his lawyer packed up. No, I admitted, but I saw the law in yours. The courthouse doors swung open. Sunlight glinted off a weed cracking through the pavement, a fleck of gold in the gray. For the first time, I hesitated before stepping over it. Case update. Voss versus Merton settled after the judge allowed the claim to proceed. The resulting statute, dubbed the Poet's Doctrine, now permits emotional distress claims for intentional destruction of non-owned art or natural beauty central to a plaintiff's cultural or spiritual identity. Critics call it vague. Eleanor calls it a footnote for the angels.